Thank you, ladies and gentlemen. You may be seated. As you will notice, the Chief Justice is not with us this morning, but she will be participating in both our oral argument through the live streaming video and participating in our conference discussion and deliberation on this case. I'm Justice Terrence O'Donnell, and I'm the acting Chief Justice in the absence of Chief Justice O'Connor. So the last case on our docket this morning is Pamela Portee et al. Versus the Cleveland Clinic. And this is case number 2017-616. And on behalf of the Cleveland Clinic, Mr. Clifford Mash.
Good morning, Chief Justice O'Connor, Acting Chief Justice O'Donnell, and Justices of the Supreme Court. My name is Cliff Mash, and I am here representing the appellants, the Cleveland Clinic Foundation, Dr. Evans and Dr. Evarding. The issue before this court is premised upon a decision from the 8th District Court of Appeals. The 8th District Court of Appeals was construing a case and was looking at the law by the pronunciation of the law of Ohio as articulated by this court in the Howard versus Allens case in 1972. And when the 8th District Court looked at that decision and considered its application to the facts of this case, the court concluded that the Howard case was either of questionable precedential value or it didn't apply to the facts of the case, and the court didn't look to the authority of this court in reaching its determination.
Mr. Mash, let me interrupt you for a moment.
Yes.
I neglected to introduce a panelist on this case. Justice DeGennaro has recused, and in her stead is Judge Penelope Cunningham from the 1st Appellate District. Welcome, Judge.
Thank you
for coming up. Excuse me for overlooking that.
That's fine, and may I reserve 3 minutes of time for rebuttal?
Absolutely.
We would respectfully submit to this court that the 8th District Court of Appeals decision that Howard's of questionable precedential value or Howard doesn't address the facts of this case is wrong. And although with all due respect, we think the 8th District Court of Appeals acted as a policy-making court and violated the fundamental rule of stare decisis, indicating that it is bound by the proclamation of this court on a rule of law when that rule of law applies to the facts before it.
Counsel, even if we, let's just disregard Howard for a moment, what about the Wasik case? Don't we have a case there that's more directly on point than Howard?
We do, Your Honor. Wasik, admittedly, was decided 9 years before Howard. And the issue before Wasik was whether or not the saving statutes applied to a federal court. What was not taken into account by the court when it focused on the Wasik case was the federal district court that was at issue in Wasik was the Southern District of Ohio. It was a court situated in the state of Ohio. So we submit that the Wasik decision can be applied in absolute compliance with the Howard decision. And more importantly, Wasik didn't look at the fundamental question of the interpretation of the statute as to...
So if it's a diversity case and it's filed in Ohio, then it does toll the statute of limitations?
I believe
is that the rule in Ohio now?
I believe, well, there's not a court specifically addressing it that deals with a federal court situated in Ohio, but I think there's a rational reason to reach that conclusion, Your Honor. And the rational reason is under the federal jurisprudence by the federal courts in Ohio, a federal court applies Ohio procedural law from the state of Ohio. And the courts have proclaimed that the procedural law it applies includes laws governing the statute of limitations. So a federal court sitting in Ohio will follow Ohio procedural law, including the interpretation that the state courts get to the applications of its saving statutes. And that's an important distinction that the 8th District Court of Appeals did not address or consider. More importantly, although
what if it was filed in Ohio and it wasn't a diversity case?
I'm sorry, Your Honor?
What if it was filed in Ohio and there was some other basis for jurisdiction? The federal claim.
The court would still, regardless of the basis of the Well, then the court would look to federal law. If there was no diversity, the court wouldn't look to procedural law.
Say, I guess this would be a pretty weird scenario, but say it was filed in federal court with some federal question jurisdiction or some other federal basis of jurisdiction, and then for whatever reason it was dismissed. Maybe it was joined with some Ohio cause of action filed in Ohio State court. Would that toll the statute of limitations, or just if it's
to the extent that the federal court was going to be looking at Ohio law dealing with the Ohio saving statutes, the federal court would be bound by, under the Erie Doctrine, to apply the Ohio interpretation.
The federal courts, the question of the state, it's a question of now when you're back in state courts, it's dismissed in federal court, right? That's the issue.
Under Howard, the court would reach a determination: was it commenced in the state of Ohio, in order to avail itself to the court. And was it dismissed, and was it filed within 1 year? The Howard court speaks with absolute clarity, Your Honor, that in order to avail itself to the saving statute in Ohio, and the Howard court says that this is a proclamation by the General Assembly. The 2305-19 is the General Assembly's statement of it, and the court said the Howard court indicates that it is within the prerogative of the General Assembly to determine the parameters of both the statute of limitations and the saving statute. And the saving statute was declared to be part of the Ohio legislative scheme dealing with limitations of actions. So what the Howard court does was it looked at the interpretation of 2305-19 to determine when does it apply, and it indicates it commence. And the court says, well, the statute doesn't specifically define either the terms commence or attempted to be commenced. So the court looks at Ohio Civil Rule 3A. And the court reached the determination that in Ohio, in order to commence or attempt to commence an action, it has to be in a court in this state. And based on that interpretation and that construction, Allen stated with absolute clarity that the saving statute in Ohio is limited to actions commenced in the state of Ohio, and that it has no application to an action that is commenced outside of the state of Ohio. Part of the rationale and justification for this court's articulation of that holding in Allen was that a state other than Ohio has no more ability to adjust or modify this court's saving statute, as an unexpired cause of action outside of the state of Ohio can somehow impact a cause of action in the state of Ohio. We would submit to this court that this principle that has been pronounced in Allen has existed for 40 years. And there's been, other than the Vaccarello case, there's been no decision by this court that has addressed it and discussed its limitations. Now, the Vaccarello case admittedly created an exception, but the exception was defined very narrowly. And the exception in the Vaccarello case was that it doesn't apply to a class action, either filed in an out-of-state state court or a federal court. And the justification for that is really apparent on the face of the rules of class actions. And that was, the court said, listen, class actions are to create efficiency and promotion of resolution of cases involving a vast number of people. The rule of Howard versus Allen would somehow complicate that, and it would also say that in order to avoid Howard Allen in the world of class action litigation, you would have Ohio potential members of the class file their own individual causes of action in order to protect themselves should the class action certification be denied in an out-of-state state court or an out-of-state federal court. So the court in Vaccarello said, this rule in Howard, we're going to create an exception, and as it relates to class actions, and the Vaccarello case modified the holding in Howard only to the facts of the Vaccarello case.
Counsel, we've talked a lot about the case law interpreting the statute, but what about the language of the statute itself? We only get to interpretation if the language is ambiguous. Here, you have a pretty clear statute that talks about any action having been filed. Doesn't any action include a federal court action out of state?
Not based on the analysis applied in the Howard case. And I would point out to this court that the savings statute rendered in the Howard case has been modified by the General Assembly twice, in 2004 and 2010, but it has not been modified in any way, or fashion that would be significant to the issue before this case. And the Howard case says it reached to the Ohio Civil Rules in order to construe the statute. The General Assembly has had more than 40 years, if it chose to do so, to amend 2305-19 if it was in any way in disagreement with this court's pronouncement in Howard. The fact of the matter is the General Assembly has chosen not to act. And I would also point out that Ohio Civil Rule 3A that was reviewed and construed by the Allen Court has not changed in any way or fashion since 1970. The Howard case on its face applies to the facts of this case. And under this court's rule of practice dealing with adherence to stare decisis, it would take a special justification or special circumstance in order to depart from established precedent by this court. And in the Howard case, by the way, the precedent was a unanimous decision. It was a 7-0 decision. The only other case that is cited by the 8th District Court of Appeals in an attempt to indicate some questionability as to the authority of the Howard case is the Osborne case. The Osborne case doesn't even discuss the issue that was involved in the Howard case. The issue before the Osborne case was whether or not 2305-19 applied to a discrimination action under 4112. As this court is well aware, issues not, statute of limitations can be waived if not asserted. So the fact that the application of the statute of limitation wasn't before the court wouldn't have been an issue ripe for the court's decision or consideration. I would also point out that the Osborne case involved AK Steel, which is a domiciled corporation in the state of Ohio. Although it's not apparent from the face of that decision, this court can reach the conclusion that it was a federal Ohio case because of the fact that AK Steel was domiciled in Butler County, Ohio.
Are we simply talking about filing of a case outside Ohio, whether it's in state court or federal court? Does your research show that a case filed in another state and dismissed is subject to the saving statute in Ohio?
In Ohio, if we're dealing with a cause of action filed in another state court, absolutely not. The Allen Court speaks directly to that.
And then would it make a difference if it was federal or state?
I would submit it doesn't make a difference, Your Honor. Ohio has obviously the right and authority to establish the parameters of its statute of limitations and the parameters of its saving statute. And the General Assembly has done that with the pronouncement of 2303-19, and this court has construed the parameters of the saving statute in the Allen case.
So in your view, the fact that this was originally filed in the federal court has no significance in and of itself. It simply wasn't filed within the state of Ohio.
That's correct, Your Honor.
Therefore, the Ohio saving statute doesn't apply.
That's correct, Your Honor. That's precisely our position. And there's justification for that. I mean, the basis of the saving statute is to give parties an understanding and an appreciation as to the likely law to be applied in the state. When you've got litigation filed in Ohio, there's an obvious understanding and awareness of the fact that you're going to be playing under the rules of Ohio, dealing with both the statute of limitations and the saving statute. Federal courts, the federal legislation certainly has the right to define the parameters of that court's jurisdiction. And in the context of supplemental jurisdiction, which we don't have here, there is federal legislation that comes into play as to a federal saving statute that gets created. But there is no corresponding saving statute when you're dealing with the concept of diversity. And that's what occurred in this case. This was an action filed in the federal court of Indiana based solely on the basis of diversity. Unfortunately for the appellees, there was no jurisdiction over the defendants in that case. And that was the motion to dismiss that was filed. Then the court determined there was no personal jurisdiction in the state of Indiana to bring these Ohio residents into that court, and the matter was dismissed. The appellees on the record of this case, were aware of this problem because when the federal court dismissed the cause of action, they moved to have the dismissal vacated and have the federal court transfer venue to Ohio. And part of the argument that they raised before the federal court was they wanted to preserve the integrity of the Ohio claim. There was an awareness of a problem with the savings statute by virtue of how they chose to litigate this case. What I think a fundamental point for this court to bear in mind is that, again, the determination as to the parameters of both the savings statutes and the savings statutes lies within the purview of the General Assembly. This court has reviewed the statute, which contains the same relevant language that exists in 230519 today. The General Assembly has had 40 years, if it would have had any issues with this court's proclamation of how to apply the savings statute in 1972, and it has not done so. There's no basis for this court to try and reach a new legislative interpretation today that didn't exist in 1972, because we're dealing with the same statutory language and we're dealing with the same Ohio rules of civil procedure. The clarity of this court's decision in Allen was clear when it was proclaimed in 1972.
You're into your rebuttal time.
Okay, and with that, I will reserve the rest of my time. Thank you, Your Honor.
Good morning. May it please the court? Excuse me. May it please the court, my name is Dave Patton. I represent Pamela and Haskell Portee, the appellees, and I'm here today to ask this court to affirm the 8th District's judgment in this case. I'd like to pick up where Justice French left off. You asked about the statute. This case, I think, should begin and perhaps end at the statute. We have two lines of case law here. We've got the Howard line and the Wasik line, and they seem to contradict each other. Since those two cases were decided, though, the General Assembly has significantly amended the savings statute.
And doesn't that really undercut your argument? The General Assembly's amended it in the law for 40 years. They didn't change it?
Oh, not at all, Your Honor. The statute that was construed in the Howard line and the Wasik line is the statute that existed from 1894 to 2004, and it reads, in an action. In 2004, the General Assembly changed that language to say, in any action. All right? It's our position that any means any. Any means a lawsuit that's filed in a foreign state court and then is refiled in Ohio. It means,
how does the word "and" go into any change it? I mean, in an action file. Doesn't say filed in Ohio. It says in an action.
Well,
so
true,
that would
but,
mean any action, wouldn't it already?
Well, Your Honor, if you look at subsection B and C, okay, so any action, it doesn't say any action, comma, unless the action is filed outside of Ohio.
Right.
And then subsection B of that statute carves out a specific exception, railroads that go into receivership. Subsection C carves out an exception, rather several exceptions that deal with specific types of lawsuits, like separation agreements, will contests, fiduciaries, that sort of thing. None of these exceptions listed in subsection C are at issue here. So it's our position that this could be really easy for the court. Any action means any action.
Okay, well, so help me out there, though. So I'm supposed to believe that the legislature, when they amended the statute, that they intended to overrule Howard by changing "and" to "any." Why wouldn't they? If that was their intent, why wouldn't they have just said so? Why wouldn't they have just said any action in any state or something like that? Any action.
Well, Your Honor,
it would seem a pretty secretive way for them to try to overrule Howard.
Well, Your Honor, I think that's exactly what the General Assembly did, and I don't know if it was secret or not. For example, the malpractice trap that used to be within this law was remedied by adding the clause whichever occurs later.
Yeah, so that's pretty direct, right? It's pretty clear what they were doing there. But you have us believe that going from "in" and to "any" was was intended to do this, even though there's no indication other than that one letter.
Well, no, it's not just one letter, Your Honor. It's an entire word. Any means any. And the fact that they have carved out exceptions in the other two subsections of the statute suggests that any means any.
Well, doesn't the fact that they've carved out exceptions in the other two subsections mean that they chose not to make another exception here? Or
Under the principle of expressio unius, any means any. But what I think you're trying to tease out, perhaps, is the public policy arguments. Why does it read any action today, and on these other cases, the obsolete statute doesn't speak in terms of any action? Since Howard was decided 46 years ago, the foundations upon which Howard rests have eroded. For example, one of the cases that the Howard Court relied upon was a North Carolina Supreme Court, which North Carolina Supreme Court decision, High versus Broadnax. The North Carolina Supreme Court overruled that case in 1991. The Howard Court also relied upon secondary sources that spoke of a majority rule that existed in 1972. Well, those same secondary sources no longer speak in terms of a majority rule. Also, you've got California, Illinois, Delaware, New Jersey, Arizona, Maryland, and Kansas have adopted the rule that any means any, that the saving statute applies to cases that are filed in another state, dismissed for reasons other than on the merits, refiled in Ohio. Same thing with federal courts. And so our sister states are moving away from this narrow view of Howard to a more liberal view, the view that we're advocating for today. And then you've also, you've got these national changes. There's also been, the social climate has changed significantly since 1972 when Howard was decided. We have increased personal mobility, we have internet transactions, we have interstate activity, and the states that have taken this more liberal view of the saving statute are reflecting this new reality. Going back to the history of how this doctrine has played out in Ohio, again, like I said before, you've got the Wasik case and the Howard case, and if you look at the case law, they seem to be passing each other like ships in the night. You've got some districts that are saying, Howard's the rule, and other districts are saying, well, no, it's Wasik. That's all fine, but what I think is significant is this 2004 amendment to the statute, where it says in any action. And since then, to my knowledge, this court has not taken up the interpretation of what any action means. We think it means any action, but what we have now is we have a district split. We have the 4th and the 7th districts, which seem to be following Howard. The 2nd, 6th, 8th, and 9th districts seem to be following Wasik. So, for my clients' narrow interest, they want their day in court. They believe that their suit was saved by the saving statute. But the broader implications here are the bench and the bar could use some guidance from this court on this issue.
Counsel, again, I'm trying to understand this any and an. It used to say in an action commenced or attempted to be commenced, right?
Correct.
And now it says in any action that's commenced or attempted to be commenced, right?
Correct.
How's it different? Other than the letter Y.
Well, I would submit, Your Honor, it's not a different letter, it's a different word.
Okay, I understand it.
Any means any.
But in statutory interpretation, if you said in an action, it would mean any action, right?
Well, you could do what the Howard Court did, and they said, okay, what's an action mean? Okay, well, let's look to Civil Rule 3. Okay, that's a commonly accepted definition of what the word action means. Right. The problem with that, though, is the civil rules cannot impair a substantive right, which is what we have here. So I would reject this Civil Rule 3 analysis. And again, I'm gonna keep hammering on this, Your Honor. Any means any.
I know, but what did "and" mean at that time? It meant any, correct?
Well, Oh, God, I feel like President Clinton talking about what is. No,
Those are the same words, though. These are two different
right.
words.
An action is, okay.
In an action filed.
An action. I would submit that any is broader than an. Any means any. Any means an action filed in an Ohio state court, an Ohio federal court, a foreign state court, a federal court in a foreign state. And, presumably, in theory, any could even mean a lawsuit filed in a foreign country, although we're not going that far today. But certainly, what we have here, we've got a lawsuit that was filed in good faith in the federal trial court in Indiana, and that satisfies the definition of any action.
And how is that different than if it had said, still today, in an action? Wouldn't you be making the same argument?
You know what, Your Honor, I would. However,
That's because the word means the same in that context.
we can agree to disagree slightly on this, Your Honor. However, I would go on to point out that if you look at subsection B, the General Assembly specifically carved out an exception for railroads that go into receivership. And then in subsection C, they carved out a handful of other exceptions.
Not by location, but by subject of the lawsuit.
Correct, by subject matter. So again, if the General Assembly wanted to keep the Howard line of cases going, they could have added subsection D to say, this subsection A shall not apply to.
So, Counselor, have you familiar with what I guess has been called the elephant in a mouse hole doctrine?
That's a new one on me, Your Honor.
Okay,
I'm
well,
sorry.
It's kind of theory of statutory construction that says that when the legislature is altering is altering a statute, we don't presume that they make big changes through vague language or ancillary language, right? So when Congress is altering something, we're not going to assume that they did that obliquely. We assume we look and expect them to do that directly.
Correct.
I mean, here we have syllabus law in Ohio, in Howard, where the court said the Ohio Savings Clause only applies to actions commenced or attempted to be commenced in Ohio within the appropriate statute of limitations.
Okay.
So that's pretty clear law. I mean, that's couldn't be more direct on this issue. So I guess, how are we to assume that the legislature intended to change that through some really vague language and to an inning?
Well, Your Honor, I would submit that it's not vague. They added the word any. Any means any, including
Doesn't that kind of seem like putting an elephant in a mouse hole?
No, it doesn't, Your Honor. Particularly in light of the changes that the social changes and the legal changes that I went through previously. Howard was written at a different time. It was written construing a previous version of this statute. And all these other states that I mentioned before have gone the more liberal route on this issue.
If we were to adopt your interpretation, doesn't that really open the door for a lot of gamesmanship? And we don't know, we have no control over how long it may take some state to deal with a lawsuit. There may be certain counties in certain states where things drag on for a long time. We don't know we have no control over the rules that other states have about voluntary dismissals. I mean, doesn't that really open the door for a lot of things to happen as far as abusing the process?
Your Honor, I disagree. A couple points on that. In the states that have adopted the more liberal view of the savings statute, you haven't had that. The sky hasn't fallen down, okay? Also, I would think it would be the opposite. If Ohio stakes out a position as having a very restricted savings statute, then Ohioans are going to be filing lawsuits in Ohio that they ordinarily wouldn't be filing as a hedge against this very narrow, restrictive view of the savings statute. So this position actually would bring, were the court to adopt the Portee's position here, it would bring Ohio into line with the majority of the states. For example, the Kansas decision that was very well thoroughly covered in the amicus brief, and it would also it would protect Ohio plaintiffs and it would protect Ohio defendants as well because of these 2004 amendments to the savings statute. So.
That was the Seaboard case that you're referring to?
The Kansas decision?
Yes, Seaboard.
You know what, Your Honor? I'm drawing a blank. If you give me a minute, I can find it. But it was the Kansas Supreme Court, 2012 Kansas Supreme Court decision that was briefed in the amicus brief.
And they referenced and cited to the language in their savings statute, which referred to in any action.
I believe so, Your Honor.
Okay, all right.
If there are no further questions, thank you.
Thank you, Mr. Patton. Mr. Marsh, you've saved a minute and a half for rebuttal, if you care to use it.
Thank you, Your Honor. Be very brief. With respect to my learned opponent's discussion of the difference between any and, I would respectfully submit that the focus of the Howard was not on the word action, an action. The focus of Howard was on the meaning of commencement in this, of commence or attempted to be commenced. That's the part of the statute that Howard focused on. That's the part of the statute that exists in 2305-19 today. It wasn't on what the meaning of an action. And I would agree that there is no semantical difference with the term and versus any in relation to the definition of an action. I would respectfully submit that counsel's discussion of the exceptions that exist in 2305-19 does not help their case. If the General Assembly, in amending that statute, chose to create exceptions that would apply to this situation, it certainly could have done so. And by virtue of the fact that it didn't, I think it brings clarity to this court as to the existence of the law.
Mr. Patton argues that a number of states have moved to a more expansive view, suggesting that in a variety of rulings, they have permitted out-of-state filings to activate the savings clause in those states.
There are some cases that have occurred in that regard, Your Honor, but in response to that, number one, those states are interpreting their own statutes. And one of the cases that they're talking about in their brief is the North Carolina case. A point of fact is the savings statute provision in the North Carolina case is actually part of its civil procedure. It's not a statutory declaration by the General Assembly, such as we have here in Ohio. Which brings me back to my final conclusion, Your Honor, is that the Howard case has been the law of the land for more than 40 years. There has been no decision by this court that has limited the application of Howard to the situation we have before it. Appellee has not cited this court to one case that's been rendered since Ohio that dealt with a federal court outside of the state of Ohio. And by virtue of the fact that all of these facts, we respectfully submit that the 8th District decision and its conclusion that Howard is no longer precedential authority is erroneous. Howard's clear on its application of the facts of this case, and this court should be reversed on the basis of the Howard versus Allen authority.
Thank you.
Unless there are any questions, I'll sit.
Thank you.
Thank you, Your Honor.
Gentlemen, thank you for the argument. We'll mark this case heard and submitted. And as that's our final argument for this morning, we'll stand adjourned. Marshal?
All rise. Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.